trust involves a legal obligation for one group, called the trustees, to hold property for the benefit of others, the beneficiaries. Before I go into detail about trusts, I'll quickly demonstrate the mechanics, which should put you in a good position to understand the more complex pieces. To demonstrate, let's look at a simple example. We have two grandparents, A and B, who intend to transfer property to their grandchildren, X and Y. The property is some real estate. The problem is that the grandchildren are only young and are both under 10 years old. So rather than transfer the real estate directly into the children's names, the grandparents A and B decide to set up a family trust. The trust will have the following elements: the trust property itself, which was transferred by the grandparents A and B. The trustees, these are the ones who will control the property in accordance with the trust deed. In this case, the trustees will be the grandchildren's parents or the children of the grandparents, C and D. The beneficiaries. This group represents the ones who the trust assets are put in trust for, and in this case, it's the grandchildren themselves. Let's call them X and Y. And the trust deed. This document will outline the intentions of the grandparents and will say a lot of things, but the general vibe of the deed will be that two people over the age of 18 will manage the trust assets for the grandchildren. So in summary, the grandparents have left some property to the grandchildren, but it'll initially be controlled by the parents in accordance with the trust deed's instructions for the benefit of the grandchildren. This is a simple explanation, and there is a myriad of options available. However, this is the basic concept of any trust. Now that you are aware of the basic concepts of a trust, I think it's prudent to dig a little deeper into the four basic elements that must be present for a valid trust to exist. The first element is the trust property or assets. For example, plant, machinery or real estate. The second element is the trustee. A trustee can be either one or more natural persons over the age of 18 who isn't bankrupt or under some other legal disability. A trustee could also be a company. The trustee legally owns the assets of the trust but doesn't officially own the trust assets. What I mean by this is that the trustee holds the assets on behalf of the beneficiaries. The duty of the trustee is to administer the trust in accordance with the trust deed and the law, to exercise various discretionary powers. The trustee is personally liable in respect of all costs and expenses involved in administering the trust, provided the trustee has not breached their obligations towards the beneficiaries. They are entitled to be reimbursed from the trust assets in respect to any trust debts incurred. So normally the trustee has a right of indemnity, and if the trust assets are insufficient to satisfy the trustee's right of indemnity, the trustee can look to the beneficiaries to make up the shortfall. However, a trustee who is in breach of his or her fiduciary obligations can be sued by the beneficiaries. A trustee must act in the utmost good faith and in the best interests of all beneficiaries at all times. The third element that must exist are the beneficiaries themselves. The beneficiaries are the persons who collectively are entitled to receive income and or capital payments from the trust fund in accordance with the rules set out in the trust deed. And finally, the fourth and last element that must exist in order to have a valid trust is the trust deed itself. This is a legal document that outlines the rules and conditions of the trust fund. The trust deed outlines who the trustee is and who the beneficiaries are. The exact wording of a trust deed will be influenced by the taste of the solicitor drafting the document and the wishes of those giving the instructions. As a result, trust deeds will vary considerably. Apart from these four elements of a trust, other important concepts and parties to a trust include the settlor. The settlor is the individual who legally creates the trust or who settles a trust. Often this is by an initial contribution to a trustee for a nominal amount, say $20. This initial amount will be held by the trustees on behalf of the beneficiaries in accordance with the trust deed. It's important to note that the settlor has no interest in the management of the trust and cannot benefit from the trust or be held liable, and often he or she immediately disappears from the scene as soon as the trust is set up and is specifically forbidden to benefit from the trust. Finally, often the settlor is a family friend or a family solicitor or an accountant if required. The appointer. In the case of some trusts, an appointer is needed, and it's the position that has the ultimate power. The appointer has the power to remove or appoint trustees and to appoint a successor to the appointer role. An appointer can also be a trustee and a beneficiary of the trust.